Lord, may I be permitted to mention a matter? Lord, this is a matter of Durgapur Project Limited. Lord, the petitioner got expired after the writ application was filed and substitution application was allowed. Lord. But since then, Lord, the matter is pending. Only a direction is required. Usual orders are there. Hey, hand over the slip, Lord.
What direction is required?
Lord, to pay the gratuity, leave salary, and
Have you served notice upon the other side?
Lord, today in the course of the day I will serve.
After serving mention,
Lord.
plus serve the notice, then mention.
Lord.
Call the
Item number 5,
pass over.
eight, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61 to 62, 63, 64, 65, 66, 67, 68, 69, 70, 71, 72, 81, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101 to 105, 106, 107, 108, 109, 110, 111, 112, 113, 114, 115, 116, 117, 118, 119, 120, 121, 122, 123, 124, 125, and 126, 127.
কোথায় গেল? দুটোর সময় তাহলে 2 p.m. is appearing in this matter, my lord.
Yes. What is your instruction? Has it been complied with?
My lord, today is fixed for meeting, my lord, for submitting the documents of the petitioner.
Which meeting? No, notice has been served.
Yes,
Meeting
yes,
has been
my lord.
fixed.
No, notice already served, my lord.
Notice has been served. My client is here, my lord. He told me that notice. has been
Oh,
served.
what is the date fixed?
Today,
Today for what?
for submitting the documents for complying the order of his lordship.
Where is the notice? Give it to me. Show it to Mr. Dotto. Have you served it to the petitioners?
Yes, my lord.
Show me that it was served to the petitioners.
My client has not received the notice.
I shall take instruction.
No, no, no.
But the serve-
Let him show the
serve
document.
but
My
not-
client has received notice. A notice will be produced by lordship, but that notice has not been served upon my client. Let him produce the documents.
I shall
If you are not served, I will issue a rule of contempt.
My-
Show me that it has been served.
take instruction.
My client is here.
If you have served the notice, why the petitioner will not appear?
I shall take instruction. My lord.
What is the date of the notice?
13/12/2024. I shall take instruction for the my lord.
Instruction. But he told my lord that the order will be complied with. And can you see the last date of the order? And still now my
Steps
lordship,
have been taken to comply with the order.
my lord. Now you lordship order, can you see? You lordship's order.
That
Before
was on
8th
7th of January.
and before 8th November, he has to
Yeah,
comply with this order.
Yes,
After
yes,
hearing-
yes.
I am coming. As per the directed by Lordship, the Lordship directed to submit a report, Lordship.
Huh?
First, Lordship's own order. Lordship passed the order. Kindly see, Lordship.
So he
First-
says today there is the date of hearing. He has
Sir,
been
yes.
asked. Have you communicated this notice to the petitioners?
But Lordship, here, Lordship, if the Lordship today is the fix for hearing, I am not bound to Lordship give a notice. But due to Lordship, Lordship, I am coming, Lordship.
Mr.
give me-
Boisho, you have asked him to appear at the meeting. You will not inform him.
But here, Lordship, I am comply the Lordship's order. If the I am comply the Lordship's order, Lordship say division, Lordship, here Lordship pass the order. Division bench directed me to consider the matter and Lordship pass a decision. On the basis of the division bench order, Lordship pass the order. I am correct or not, Lordship? Kindly see the Lordship's order.
Yes.
Yes, Lordship.
Yes.
Lordship directed 14th 2014.
Kindly come to paragraph 14 of that order.
Lordship. Lordship. Chairman DPSC being the respondent number 4 is the direct to consider the matter fresh, strictly in the light of the objection made by the Honorable Division Bench in the order dated 8 March 2014.
Thereafter.
Upon giving an opportunity of person hearing to the petitioner, the school authority.
Have you given the petitioner an hearing?
Lordship directed.
Yes.
Opportunity, if the Lordship, on the basis of the division bench order, pass a decision.
Upon giving an opportunity of hearing.
Hearing.
Have you given him a hearing?
On the-
When have you given him a hearing?
The Lordship matter was hard. The division bench directed me to give a notice to the respondent and pass a decision order. Division bench pass. Here my learned friends saw division bench not pass any order. On the basis of the division bench, Lordship pass the order, give a opportunity to pass it. That Lordship, you give my Lordship. Here Lordship, when the division bench pass the order, I am not comply the division bench. Thereafter contempt petition will be filed.
No. Here I have directed the DPSC to consider it afresh in the light of the observations upon giving him an opportunity of hearing. Have you given him an opportunity of hearing?
But here Lordship,
You have given him a notice according to you. Today is the date
I am
fixed.
coming, Lordship. If they give me 2 minute times, Lordship.
Yes.
Here, Lordship, when the matter was hot, read petition.
Yes.
Kindly see the Lordship's first page. I am the sole authority of the DPSC. Instead, I appear. I am not appearing in this matter, Lordship, due to. But as for my.
You have not appeared.
No, Lordship,
but-
I am not appeared. No copy has been served upon me. And Lordship, here, Lordship, no observation is there. Notice has been served and nobody appeared on behalf of the DPS. There is not mentioned here, Lordship.
Yes.
Thereafter, Lordship, I am passe, Lordship, here, Lordship, on the basis of the Lordship's order, I am not comply the Lordship's order due a phrase. Lordship direct the phrase. I am not, Lordship. But Lordship, here, Lordship, my learned friend, Lordship, when the division bench pass a order, pass a reason order, I am comply the Lordship's order. Lordship contempt petition has been dropped. Lordship say, yes, you pass the reason order, there is not necessary to the rule has been discharged. Kindly see the page, Lordship. Rule, kindly see the Lordship. Page there. Division bench passed the order, I am passed. Lordship, division bench say, kindly page 34. My learned friend appear in this matter, Lord. In contempt petition.
Page 34.
দর্শকের কাছে নেই, আমি তো এটা
No,
Lordship, I am not a file of. Here, Lordship, one moment, Lord. I am not sub that.
এফামি হয়নি আজকে।
Kindly see the Lordship. Division bench, my learned friend appeared in this matter.
Yes.
He did not disclose before his Lordship.
Mr. Bhoisho, your learned junior has placed a notice.
Yes, Lordship, I know.
Today is the
Lordship.
date fixed for hearing.
Yes, Lordship. But
So have you, Mr. Dotto says
I
the
am
notice
giving
has been
what-
served.
the Lordship. But I am giving the Lordship. I am the.
Today is the date. How he will appear?
Why I am not service copy?
Yes.
সার্ভিস করেছি
সেটা আমি ইনস্ট্রাকশন নিতে হবে, কারণ
না না এই কপিটা ওনাকে
I will clear to your lordship.
ওরা করে দিয়েছি বলেছে।
ওরা করেছিল as per my instruction copy has been served.
Mr.
You mentioned
Dotto
one-
says
You
the
got
copy
my
has
la-
not been
what
served.
lordship?
Today is the date fixed for
Lordship.
hearing.
My
So,
lordship,
Mr. Bhoisho, can you ask your officers to fix another date? If you give a date, I
But here,
will
Lordship-
direct him to appear on that date.
lordship.
Take
But
instructions
here,
from.
no lordship. Okay, Lord, I am lordship. I am giving a lordship as per the Lord. But lordship, my submission, lordship, when the lordship, I am read petition. If they suppress the read petition, no.
You
But
deal everything, pass a reasoned order.
I pass the but lordship. Why the misguide before this court? When the contempt petition is dropped,
Yeah, but
chapter
let's-
is closed.
Well, let make me clear.
Chapter is closed.
Mr.
Then
Bhoisho,
the again say come with.
then Mr. Bhoisho, you have to
I
apply
comply
for.
contempt. I am nothing to say, lordship. I comply the lordship.
Since
Yes.
you have, according to you, you have
Lordship.
fixed a date of hearing
Lordship,
today.
I am
and
further notice.
Mr. Dotto says his client.
Again,
is-
I mean, as per your lordship.
So you take instructions. What will be the next date? I will direct him to appear on that date so that there will be no necessity of issuing further notice.
Lordship, fix the date.
You ask your officers, what will be,
As per lordship, fix any day.
give me a date subject to the.
Lordship, I am not saying lordship, any day of the lordship.
Mr. Bhoisho,
Lordship,
kindly
not
ask your.
not necessary, lordship, not necessary. I am,
কথা বলছি, কথা বলছি।
lordship, it is my confidence, if the lordship.
Next Friday, next Friday,
Yes, yes,
Friday.
yes, lordship, I am not put the,
No, only one thing, my lord.
then
give
lordship,
me that notice.
lordship, then lordship. ওটা কি বলেছেন?
অর্ডারটা কমপ্লাই করার জন্য আজকে
10th of January. So according to you, you are not aware. I am fixing 17th of January. This hearing will be held.
Lordship, at 2 p.m.
17th of January.
Yes, next Friday.
At-
Because today you cannot appear.
No, I
Can
cannot
your
appear.
client appear today? Cannot. So I am fixing it on 17th
lordship, okay.
At 2 p.m. No, only one thing.
at
Before
2 p.m.
No,
Yes.
only one thing. Before passing this order, 2 minutes, man, kindly. Then. What Mr. Bhoisho is submitting to the lordship is that I am not stated in my writ petition that earlier the contempt has been filed and that contempt has been discharged. This is his case. I have not stated in my petition. In my no, only one,
Now,
thing, no, only one thing, mal, kindly, sir. Why? Because he is making that submission which is not mal, appeared in the record. Now, what I am submitting, my lord, division bench passed an order. Your lordship has observed the division bench order. Now, again, this order has not been complied. That's why I filed an contempt application.
All right. Now he has given him a note, given you a notice. Today is the date. According to you, you have not been served. I am fixing on 17th.
Lordship,
There will be no requirement of any fresh notice.
lordship.
You will appear before the office of the chairman on 17th at 2 p.m.
At 17 at 2, lordship, I am. Leave has been granted, lord.
Yes.
And
My junior
necessary,
is here.
and when necessary document to be produced before that authority.
Yes, you produce.
All I am not only the date of hearing. I am
Yes,
only
No, I-
fixing
because
17th.
liberty is with the petitioner to submit all relevant documents.
What is there? It is there. Only the date I'm fixing on
one date.
17, nothing more.
I have
Mr. Boisho, learned additional government leader, appearing for the
Here, Lordship, I am not a Lordship, appear on the advocate, Lordship, not for the additional government. Either DPSC, Lord.
yes, sorry. Mr. Boisho, learned advocate, appearing for the alleged contemner, submits that pursuant to the order dated 17th of September 2024, a notice wide memo dated December 30, 2024 has been sent to the petitioner fixing the date of hearing today, that is bracket element, that is on 10th of January 2024 at 2 p.m. Mr. Dotto, learned advocate, appearing for the petitioner. Mr. Dotto, your client is present in court.
Yes, yes.
Upon taking instructions from his client, who is present in court today, submits that the said memo has not been served upon the petitioner till date. However, without entering into such controversy, as suggested by the learned counsel for the alleged contemner, the date of hearing by the chairman, District Primary School Council, North 24 Parganas, is fixed on 17th of January 2024 at 2 p.m. First up, let a copy of this memo be supplied to Mr. Dotto in course of this day. Oh, you have a copy. A copy of the memo dated 30th of December 2024 has been supplied to Mr. Dotto in course of hearing of this application. First up, list this matter on January 30, 2025 under the same heading. Kept with the record. A copy of such memo is kept with the record, which is produced in court today, is taken on record. Yes, call the next one.
Eight.
But today, they were supposed to file a fresh affidavit indicating as to when and within which time they will going to purchase complete the process of purchase.
Where is your friend? Has he come to court?
Yes, yes.
Passover?
Passover. Kindly take it up, fix up a date. Passover means, it will be again when called, I don't know. Kindly fix up a date then. Kindly make it, kindly fix up a date.
Mr. Pan, learned advocate, appears for the petitioner. None appears for the state. List this matter in the next week under the same heading.
Under the same heading. Obliged to us.
Yes, next.
50.
I appeared for the Malad. Yesterday I could not appear Malad because I was in court number 1238 Malad.
Yes. Bandyopadhyay, affidavits have been
Yes,
filed.
yes.
Affidavit is long back Malad.
It's a all old virtually matter of 2008.
Yes. What is the issue?
My issue is, my lord, payment of, my lord, higher salary. I'm just telling you, lordship, the facts. My lord, in 1980, my lord, 84, the petitioner was appointed. My lord, at that time, the institute was, my lord, the Industrial Training Institute. At that time, those ITRs were known as Industrial Training Institute, not as laboratory assistant. Although he had the required qualifications of being appointed as instructor or teacher. My lord, these ITI trade courses, my lord, were abolished, my lord, in 1990.
What were abolished?
These trade courses, Industrial Training Institute trade courses, there are courses, my lord, which required the use of laboratory. So after these courses were abolished, my lord,
In 1990.
1990. So there is no job of laboratory assistants, my lord, in the institute. Then the petitioner was asked to, my lord, take the classes for workshop calculation and science, my lord, as a teacher, instructor. My lord, these first,
You had the requisite qualification for that post.
he had the requisite qualifications. One of the undisputed. Page 40, one of this first memo of 7th November 1991. Kindly take a look of page 40, or I'll just narrate the fact.
What is the broad issue? What
The
happened?
broad issue is he was always being paid the salary of laboratory assistant despite discharging the function of a teacher. There was, this is second round, third round of litigations virtually. In the first round of litigations, this Honorable Court directed them to consider his case for a higher salary. That first order was passed in 1997, 16th May 1997.
His case for higher salary. What happened after that?
After that, the director, my lord, passed an order. My lord, he said that exact scale of teacher will not be given, but he is entitled to some higher salary.
Than the laboratory attendant. Higher than the laboratory
Higher
attendant.
than the laboratory assistant.
But
But some
not-
extra remuneration should be given. That was the findings of the director. And it was referred to the government.
That was referred to the government.
Government.
Government approved, no.
No.
Till today, no approval.
Then, in the next
But
litigation.
you did not challenge that decision.
No, I didn't challenge. I didn't
Accepted
challenge.
that.
I didn't challenge. Well, thereafter, again, the further order, the further writ petition was filed. And in 7th January 1998,
What was the relief claimed in the second writ petition?
for the implementations of that order of the director. But I cannot, my lord, go behind what has reached finality.
Yes.
But in 1998, the court directed that you please implement this order of the director. That has not yet been done. Even I retired. Page 40. Now, what thereafter
So now
happened?
you are really trying to execute the order passed in the second writ petition.
No, there are further cause of actions also. My lord, this is also permissible. Your lordship is aware of that. Even if there is no contempt, I can file a second writ petition for implementations of the order of the. Now, what happened, my lord? I continued as a teacher because there was no post of laboratory assistant. Now, the second came on 4th August 2006 when I am specifically asked again to take up, my lord, in fact, I was directed to officiate a function of a teacher who just retired in 2006. Well, that resolution was adopted by the institute. This was sent to director for approval. That
So according to you,
there are
by
two stages.
virtue of that office order, you have been appointed in the post of a teacher regularly by virtue of
Not
that.
regularly.
Lab assistant.
It is.
You will get your chance. Take
No,
your
no,
seat.
no,
It is called officiating. It is the ad hoc appointment that since he had retired, you discharge his functions. This happened in 2006. So from 1991 to 2006, according to me, he was entitled for the higher remuneration as per director orders. But after 2006, he was entitled
For
for
the post of
scale,
a teacher.
scale of the
Remuneration
teacher.
For the post of a teacher.
Post of teacher. Now that has not been done. In the meantime, this institute upgraded, in 2009, upgraded as ITI, full scale ITI. Thereafter, the petitioner was directed to file an option form. That option form, that was, he filled up as
Option for
option for to be governed for the new ITI. There are others that has been done. Nothing, no payment. This petition is pending since 2008. I'll just show 3 documents only, not first. You'll also kindly take page 40.
Yes.
Since the laboratory work is not required for ITI trade courses, students and see Alok Kumar Mukherjee level is BSc B.Ed. But I'll show that this was the required qualification for being. He is directed to take the workshop calculation and science classes of ITI trade courses students with immediate effect till any directive is received from the Director, Technical Education, West Bengal. This order was given in pursuance of Director Technology memo number such and such 7th July 1990. That was abolitions of
Do you have a copy of this order?
most probably
7th July 1990.
this is an upgradation. I'll show it from other documents also. That's earlier repetition.
All right.
Then after that, he continued to take up this. Now, next, he currently take the order dated 41, the first read.
Page 41.
Page 41. 16th May 1997. This is a direction for considerations of his representation for higher remuneration.
Yes. Then what happened after
Then
that?
this the order of the director.
Page 42.
42. Director narrated all these facts.
Yes. Then what is the ultimate?
Yes, kindly take page 43.
Considered for an extra remuneration.
Yes, in my opinion, as suggested by the Joint Director, such and such, the petitioner may be considered for extra remunerations as the work assigned to him is higher responsibility in nature.
So
But-
this is in a form of a recommendation.
Recommendation, but this office has no authority to sanction remuneration. Hence, the
So
case
recommendation.
Department of Technical Education for remuneration. This was not complied with. This was nothing was been paid. Then, my lord, the director had also, my lord, communicated this, my lord, by with a further communication, page 45, to the Secretary to the Government of West Bengal. Kindly see the last paragraph.
Yes, to
In
sanction
this
the extra remuneration.
Yes. Now, this was also not done. Then the second round of litigations came, my lord, page 46. This is January 7, 1998 order.
Yes.
First read. My lord, kindly read the director has, however, has you also got it 5 lines from the bottom. First page.
Yes, yes.
The director, however, passed an order after detailed hearing recommending the matter to the finance department since it involved payment of external. But even after such recommendation, when the finance department did not take any further action, the petitioner has again filed this case. Then, Mala, next page 47. Undisputedly, the petitioner has been working as instructor in science. He is entitled to some extra remuneration as suggested by the director. But what would be such remuneration has to be assessed by the finance department by taking the workload which the petitioner has been discharging at the moment, and also keeping him view of the order in view of the other precedent cases. I hereby direct the finance department to examine the petitioner's case and pass final order within 2 months from the date of communication. But duly communicated, no order was no payment was made, no order has been made for determining the higher remuneration.
Yes.
Then, my lord, the next phase started, page 48. you are hereby directed to take classes of workshop calculation of all trades items as the AK Sen, instructor, another instructor in science, has retired due to his superannuation on 31st July 2006, who was taking the classes of workshop calculation science of fitter and tumor trades. This was done on 4th of August 2006. The resolution is at page 50. Before that, this was forwarded to the director. Kindly take page 49. It was forwarded to the director by a communication dated 8th November by the institute. This enclosed the resolution.
Yes.
Page 50.
What's the page?
50.
Yes.
The GB accorded the application submitted Mr. Lab Assistant in connection with the situations arised after superannuation of teacher in science of the institute. The proposal made in the application is considered, and GB unanimously decided it fit to approach the Director of Industry to move the government to permit Secretary such and such to make it effective to run the classes of workshops calculation science smoothly without any extra financial. The GB requested Secretary to move DIT accordingly.
Yes.
Now, for the qualifications, my lord, kindly take page 51. This was the sanction of staff sponsored junior technical school. At that time, junior technical school. This should have been the salary, serial number 4.
Instructor in science.
Yes, his qualifications, your lordship, required qualifications is at page 54.
Trained graduate in science.
Trained graduate in science. Now the petitioner is BSc with B.Ed, as was recorded, my lord, at the first when he was in 1991.
Now, what is their stand?
Nothing, my lord. In the affidavit, they had filed an affidavit. I don't think whether it is there in the file or not, but I was served with a copy of the affidavit. The only stand, since he was not regularly appointed as teacher in the vacancy, so he is not entitled.
Mr. Kundu, no affidavit is in the record.
Well, I am not, at that point of time, Lordship's direction matter was.
But I can supply your lordship a copy of the affidavit in opposition.
So, do you have a copy of the affidavit?
Yes, I have.
I have supplied it.
Yes,
I have supplied it.
supplied it.
Extra copy.
Yes, give me a copy of the
Yes,
affidavit.
my lord, kindly take my copy.
You don't have an extra copy?
For the time being, I don't have extra copy. I will take it. And
He's after that. No, hold it.
that's it. Can I take page 4?
Yes.
In this regard, the answering response, I don't, this industrial training centers are run by grant in aid, whereas industrial training institute are purely government. But ultimately, this has been upgraded to ITI. It appears the petitioner is purportedly claiming regularization. I was not claiming regularizations. In the said institute, the petition is working, especially after one such post has fallen vacant with the superannuation of one employee. In this year, petitioner has lost sight of the very fact that even if any incumbent is rendering the service of instructor, it cannot be automatically.
No, Mr. Bandopadhyay, what is their stand with regard to the recommendation being made by the directorate?
Nothing is virtually Now kindly take page 8.
Yes.
Paragraph, my lord, it should be.
Target.
Hmm?
11.
I need. Page 11, taking classes of works of calculator. It is noteworthy that the contents of the paragraph are true to the knowledge of not all the answering respondent further denies in particular the petition has not been given and the pay scale of the instructor which he was entitled do not principal equal pay, but also very vague.
Only denial.
Only deny very vague affidavit. My lord, nothing has been stated.
Yes,
Lord,
Mr. Kundu,
page
what is
8.
your decision? Because
Lordship, kindly see that.
there was a recommendation being made.
Lordship,
What
kindly
is your
see
decision
last
on
page of supplementary affidavit. Lordship, kindly see last page of supplementary affidavit, that is page 22.
supplementary affidavit filed by the petitioner? Filed by the petitioner?
Application or supplementary affidavit
Application.
filed by the petitioner.
There is a can. my lord,
There's the
filed
can.
After my lord, is upgraded to my lord ITI.
No, can to, where is the supplementary affidavit?
No, there it is can.
Can, Lordship,
Oh, can.
can.
Can 2 of 2021?
Can.
No, can is my lord.
Can 706 on 2009. 29, madam.
Can 7061 of 2009.
7061 or 6071?
7061.
Maybe it can.
Kindly take up this.
6071. Most probably 6071. This
Whether it is this application.
this.
দেখো তো এটাই কি লাস্ট পেজটা দেখে নাও তাহলে
This is can 2 in 6071. My lord, original 6071.
No, I have found 7061.
Yes, that is why
7061.
7061. I was referred.
All right.
লাস্ট পেজ লর্ডশিপ can see page 22.
Page
22 last annex chart লর্ডশিপ বেশিটা করে
The
দিই
option
page 21 is the last, not 22.
21, you are most probably.
লর্ডশিপ can 22 this is
I do not have page 22.
no দেখো না
No, I do not also have page 22.
21 is the provisional option form. Kindly check up this. Dekhanto.
This is the second of the retirement. 22, I do not have.
21 years.
How could you have, Mr. Kundu? Petitioner is not having.
লর্ডশিপ can
You also do not. I also
supplied
do not
by-
have. You are having.
supplied by লর্ডশিপ can see
No, I supplied, but I don't have that page.
he supplied my lord
ফিরে গেছেন? এটা কি? এটা
নেই তো নেই
না, অরিজিনালেও তো নেই।
না অরিজিনালও নেই তাহলে এতে কি করে আসে হ্যাঁ ও তার মানে খুলে গেছে মনে হচ্ছে
খুলে-
কিন্তু লাস্ট
দেখিয়ে
ব্যাকশিটটা
দাও
তো
না
আছে
যদি থাকে। কি
ব্যাকশিটটা
আছে
আছে
আমি জানি না।
ব্যাকশিট আছে কিন্তু এটা কার এটা তোমার
What was WP 2220 W of 2016?
No, that has
Most
become
probably,
infractuous. That is relating to Malad option.
Mr.
They
Bandyopadhyay,
stop salary.
kindly look at this
They
because
stop salary.
kindly look at this.
Yes, yes, I now remember, but I have the copy of that. No, no, এটা না। Malad, his salaries were stopped because of Malad non-furnishing of the option. That was page 20.
Now it has been
The salaries were released, that is of a laboratory assistant.
of the laboratory assistant.
Laboratory assistant. That was stopped for nearly 1 year. So that was directed to be released.
Yes,
As
Mr.
soon as
Kundu,
this
only
petition
one
was
thing.
filed, it was,
The
well, I'll be just relying on two judgments, Malad.
prior to that, there was a direction for you to consider, there was a recommendation.
লর্ডশিপ can
So recommendation was there. What is the decision on that recommendation?
no record, no instruction has yet been received from till today. Lordship can directed to directed lordship respondent number 3 to give on the basis of the recommendation, Lordship kindly pass the order. No respondent number 4, Lordship, no instruction has been received till today.
Because on the basis of the recommendation, you have to take a decision. So now in the affidavit also no positive.
Nothing.
You are entitled, you are not entitled, nothing has been
Nothing
stated.
Nothing has been, Lordship.
But in fact, my case was that from 1991 to 2006, I was covered by that order. But after 2006, when I was specifically directed to take the classes of a teacher and I was having the required qualification, they're bound to pay me the scale applicable for the post of teacher. That was the decision of the Supreme Court. Two decisions on the same issue.
But Mr. Bandyopadhyay, the only difficulty is that no decision of the authority is before the court.
Yes, that
So,
there is.
I cannot consider whether their decision is wrong, right. So they have to be directed to take a decision.
Your lordships can consider their affidavit also because the
Affidavit, nothing, silent.
nothing, silent.
So,
But they did not deny that I was not taking classes of a teacher.
no, yes, even assuming that, they have to make out a case whether you are at all entitled to or you are not entitled to, citing ABC reasons, then you can
No,
challenge
the
that.
director had found I am entitled for a higher remuneration.
Yes, higher.
Only finance department was, my lord, the
Higher remuneration, what should be the higher remuneration? Nothing has been.
nothing has been.
So
But
there is,
the Honorable Justice Panigrai directed that it should be approved by the finance department.
Yes.
That has not also been done. So now question of my entitlement for higher remuneration, that is no longer an issue. The issue is what should be the higher remuneration and how it is to be paid. That was the issue.
what are the
Yes.
decisions you are?
My lord, first decision is 2013 4 SCC, page 152. My lord, kindly take paragraphs 13 to 15. Plus, you can take the my lord, facts also. They are, my lord,
Paragraph
13 to 15.
Page kota bole page ta?
Page হচ্ছে 152. My lord, additional, my lord, assistant CDPO was asked to officiate in the discharge the function of CDPO. Now the Supreme Court said that they are bound to pay the salary, my lord, applicable for the post of CDPO during that particular period. In the same, my lord, fact situation,
yes.
the same. There was no regular promotions, or here there was no appointment.
But in that case, there was a decision which was challenged. Here, it's nothing.
And that was the tribunal decision.
No. As well as the authorities.
Yes. Now here
Authorities' decision was under challenge before the before the tribunal.
Yes. Now the same fact situation. Now another judgment, 1998 4 SCC.
The impugned order as well as the one passed by the tribunal are set aside.
Yes. But here there is no order.
Yes.
Here there was an order originally of director, but after 2006 there is no further order. There are representations also, my lord.
There were representations.
After 2006,
show me that. There you must have make a comprehensive claim that from 2006 I'm entitled to the salary for.
I have to check. This is virtually.
There was no vacancy.
At that time, I was also not appearing. Somebody else was handling. No, there is no representation annexed. No representation. I'm sorry, my lord.
Then, Mr. Bandyopadhyay, it would be better because now, otherwise, piecemeal direction to consider will be of no use because now there are two issues. One is prior to 2006
and after
2006. So prior to 2006, according to you, you are directed to or you were asked
Higher
to
remuneration.
perform some additional work in a higher post, and you had the requisite qualification for holding that post, and it was also not a stopgap arrangement, you continued from that date till 2006, and from 2006 also.
Till my retirement.
So it's all along in the post of the instructor,
As in all,
all along in the post of instructor.
but since
But
1994.
prior to 2006, since you have not challenged that decision,
Yes.
you
that-
cannot say that
No, no,
prior
no.
to
Yes,
2006,
absolutely, absolutely. I,
I'm
prior to
entitled to the
2006, I am
salary of
only
Laboratory
entitled for higher remuneration
higher
as per
remuneration as
director
per
order.
this.
I cannot. But after 2006, but I can show other judgments also. 1998, my lord.
No use multiplying.
Yes, 1998, 4S is the same. Now, so far as the equal pay, equal work, but your lordship is well aware of Justice Kehar's judgment, 2017. Lord, I have a copy. I can that in no manner the nomenclature is. If I have done the similar work, I am entitled.
I'm directing them to, I'm giving you a liberty to make a comprehensive representation with regard to that. Let them take a decision citing all these.
Or let the writ petition be treated as representation.
Mr. Bandyopadhyay, can a writ petition be directed
Now
to
he
be
is a
considered?
retired person. He is waiting so much.
Because writ petition, Mr. Bandyopadhyay,
But
not good.
unless your lordship observe something.
Yes, yes, yes. I will make those observations.
করতে হবে কি করতে হবে এখন তো
এই যেমন মনে হয়, দেখো এটা মনে হয় রেসপন্ডেন্ট নাম্বার 4 দেখো তো।
Respondent number 4.
হ্যাঁ,
The petitioner
সেক্রেটারি কি করলে হবে না
No.
claims to be a graduate in science
ডাইরেক্টর
and also possessing the B.Ed qualification.
হবে না।
Respondent number 2.
টেকনিক্যাল
The
পার্টি নেই,
petitioner
পার্টি করতে বলতে হবে। পার্টি নেই তো।
ও এখনো
was
আছে তো
appointed in
দেখি অ্যাপ্লিকেশন
Shoroji Prasad Junior Engineering Institute
এই তো দেখো।
in the post of laboratory assistant in the month of
একেই করতে
June
বলছি।
1984. Mr. Bandyopadhyay, kindly hear the order.
Yes.
In June 1984,
Yes.
in the scale of rupees 300-685
685.
plus admissible
DA.
dearness allowance and other allowances. Full stop.
1990 অর্ডারটা দাও
মেন মেথডটা
After successful completion of the probationary period, the petitioner was confirmed in the said post. In the year 1990, the Director of Technical Education, Government of West Bengal, introduced Industrial Training Institute trade courses in 19 junior technical schools in West Bengal,
That is the memo dated 7/7.
and as a result of which there was no work for laboratory assistant in any of the junior technical schools wherein ITI trade courses had been introduced by the government of West Bengal. The institute, ওই যেখানে সরোজি ওই পুরোটা করেছি না, ওখানে লিখবেন ব্র্যাকেট দিয়ে for short the institute. The institute directed the petitioner to take workshop calculation and science classes of ITI trade courses in the said institute by letter dated 6th of November 1991. Since the petitioner were performing the duties of a higher post, he submitted a representation claiming higher remuneration by taking higher remuneration on the principle of equal pay for equal work. The alleging inaction on the part of the respondent authorities, petitioner approached this court by filing WP number 966 of 1997 and which was disposed of by an order dated 16th of May 1997 by directing the Director of Technical Education, West Bengal, to pass a reasoned order upon considering the representation made by the petitioner. Pursuant to the said direction, the Director of Technical Education, West Bengal, passed a reasoned order vide Office Memorandum dated 14th of August 1997 full stop. Full stop. Passed an order vide ato, wherein it has been suggested by the joint director that the petitioner may be considered for an extra remuneration as the work assigned to him was of higher responsibility in nature. Full stop. However, since the authority, that authority had no authority to sanction remuneration, the matter was referred to the Department of Technical Education and Training for sanction of remuneration to the petitioner. The Director of Technical Education, by a memo dated 12th November 1997, requested the Secretary to the Government of West Bengal, Department of Technical Education and Training, to sanction extra remuneration to the petitioner at the rate as may be deemed by the deemed fit.
Yes.
So it has, by passage of time,
It has gone.
as may be deemed fit by the government with effect from 7th of November 1991. Full stop. Since even after such recommendation, the Finance Department did not take any further action, the petitioner filed another writ petition being WP number 2445 of 1997,
Yes, my lord.
which was disposed of by an order dated January 7, 1998, by directing the Finance Department to examine the petitioner's case and to pass a final order within the time limit as may be specified in the said order. It would be paragraph. It would be relevant to point out at this stage that This honorable court, in the order dated January 7, 1998, in WP number 2445 of 1997, specifically observed that the petitioner was undisputedly working as an instructor in science, and as such he was entitled to some extra remuneration as suggested by the Director of Technical Education. But what would be such remuneration has to be assessed by the Finance Department by taking into consideration the workload which the petitioner has been discharging at the relevant point of time, and also keeping in view the other precedents. First up, thus, the entitlement of the petitioner to some extra remuneration over and above the remuneration that the petitioner was entitled to for the post of laboratory attendant is not in dispute.
Yes.
First up, the issue which requires to be adjudicated / decided by the Finance Department is only with regard to the quantum of such extra remuneration and not the entitlement in respect thereof. However, subsequently the petitioner, however, an instructor in science of the said institute retired due to superannuation on 31st of July 2006, and the secretary of the said institute by a letter dated,
It's an order, my lord.
by an office order dated 4th of August 2006, directed the petitioner to take classes of workshop calculation and science subjects of all trades of the ITI students. First up, upon going through the said office order, this court finds that the petitioner was directed to discharge the duties which was being discharged by the erstwhile instructor who superannuated on 31st of July 2006. Record reveals that the secretary of the said institute, by letter dated 9th of November 2006,
8th of November. 8th of November.
8th of November 2006, forwarded the resolution of the governing body of the institute to the Director of Industrial Training. First up, the Chief Inspector Technical Education.
No, this was I relied on to show that the scale.
Yes,
is,
yes.
The qualifications, page
Full stop.
54.
Paragraph. Mr. Bandopadhyay, honored senior advocate appearing for the petitioner, submits that prior to the issuance of the office order dated 4th of August 2006, the petitioner was entitled to some extra remuneration as directed by this court by order dated January 7, 1998 in WP number 2445 of 1997. He further submits that immediately upon issuance of the office order dated 4th of August 2006, the petitioner is discharging the duties of the instructor by taking classes of workshop calculation and science of fitter and tumor trades.
In the, after the retirement of,
Yes, yes. I said after with the issuance of that office. Full stop. Mr. Bandopadhyay submits that since the petitioner had been discharging the duties of a higher post for a sufficient what should be the period? On and from
for no specified period. It was not for a specified period, unspecified period.
for quite a long period of time. The petitioner is entitled to the remuneration. না এটা কি বললাম? Mr. When he retired?
In 2018, most probably, my lord. I need to take it.
তাহলে কি হলো?
Till his retirement, my lord.
না ওটা কেটে দিয়ে লিখুন with effect from 4th of August 2006 till the date of his superannuation, he is entitled to the salary and other benefits as that of an instructor. Full stop. In support of such contention, he placed reliance upon a decision of the Honorable Supreme Court in Arindam Chattopadhyay and others versus State of West Bengal and others, reported at 2013 4 SCC 152. Full stop. Paragraph. Mr. Kundul, honored advocate, appears for the respondent. Full stop. He submits that the petitioner he submits that the case of the petitioner for higher remuneration was forwarded to the competent authority, but till date, no decision on such recommendation has yet been taken by the authorities. Full stop. Since a recommendation was made by a competent authority, and this honorable court by order dated January 7, 1998, directed the finance department to examine the petitioner's case and to pass a final order upon observing that the petitioner is entitled to some extra remuneration as suggested by the Director of Technical Education, this court is of the considered view that a direction should be passed upon the appropriate authority of the government to take a decision in the light of the observations contained in the order dated January 7, 1998, as well as full stop. An affidavit in opposition has been filed by the respondents. Full stop. After going through the said affidavit in opposition, this court finds that the respondent authorities have upon going through the said affidavit, this court finds that the denials made in the said affidavit are only vague. Full stop. No specific case has been made out denying the claim of the petitioner as made out in the writ petition. Full stop. The fact that the petitioner had been discharging the duties of higher responsibility has also not been denied by the respondent authorities in the said affidavit in opposition. Full stop. This court therefore, the claim of the petitioner for higher remuneration prior to the issuance of the
4th August 2006.
office order dated 4th August 2006 is required to be decided in the light of the observations contained in the order dated January 7, 1998, passed in WP 2445 of 1997. Insofar as the claim of the petitioner for higher remuneration with effect from the date of issuance of the office order dated 4th of August 2006 till the date of superannuation of the petitioner is concerned, this court feels that a liberty is to be granted to the petitioner to make a comprehensive representation before the concerned authority, ventilating his claim with regard to the high scale of pay. Let a comprehensive representation be submitted by the petitioner before the
Respondent number 2, because Director of Industrial Training.
before
Could have
the
been Director of Technical Education.
before the Director of Industrial Training, being the second respondent within a period of 3 weeks from the date of receipt of a server copy of this order. The said representation shall be accompanied by a server copy of this order. If such representation is submitted before the second respondent, the said respondent is directed to consider the claim made by the petitioner in the said representation and to dispose of the same in the light of the observations made in the order dated January 7, 1998, passed in WP number 2445 5 of 1997, as well as the observations made herein before.
I'm grateful, my lord.
First up, it would be open to the petitioner to place reliance on any government orders, notifications, as well as any decisions in support of the claim for higher scale of pay at the time of hearing before the state authority. That's opportunity of hearing ki bolechi na letter bole pass the result out upon giving an opportunity of hearing to the petitioner or his authorized representative. That's it. And to communicate the reasoned order to the petitioner immediately thereafter.
The time frame.
The entire exercise shall be completed by the second respondent within a period of 4 weeks from the date of submission of the representation pursuant to this order.
Grateful, my lord.
First up, in case the second respondent is of the opinion that the petitioner is entitled to higher remuneration, such authority shall immediately forward the papers as well as other documents to the concerned authority for taking necessary steps in that regard.
Great.
Disposed of, no costs. এখানে একটা লাইন রেকর্ড করে দিন যে Mr. Bandyopadhyay, please give a photocopy of this. I am returning.
Your lordship, kindly keep it. I have
You will
got
not be having a copy.
Yes, yes, yes.
You are having a copy.
Yes, yes. But I've just removed the back seat.
Since the affidavit in opposition
Back seat.
is not on record, and Mr. Kundu, learned advocate, appearing for the respondent, submits that he is not in possession of the original affidavit in opposition, a photocopy of the affidavit in opposition filed by the learned advocate on record of the petitioner is taken on record. First up, the photocopy of such affidavit in opposition shall be treated to be the original till the original affidavit in opposition is filed before this court.
Grateful, my lord.
Yes, call the next matter.
51.
51, my lord, I am for the petitioner, my lord. On the last occasion, the answering respondent has filed a report in the form of a supplementary affidavit. Direction to file exception to that was given, my lord. But only difficulty is the advocate on record, Mr. Nilesh Gupta, underwent kidney tumor operation in the month of December.
What do you want?
But I'm praying for 2 weeks' time to file my report. He has joined office on Monday.
Exceptions to the report.
Exception to the report.
As paid for by the learned advocate for the petitioner, the time to file exceptions to the report is extended by 2 weeks from date.
Deeply obliged.
This matter after 2 weeks. Next.
Deeply obliged.
Fifty-two.
Pass over next.
53.
I appear for the respond this matter, my lord. On the last occasion, I have said, my lord, a division bench has passed the order
53,
on
I am for the,
on a similar identical point, my lord.
no, it's not identical.
Not identical.
Not identical, but I am only praying before, let's say, I kindly give me 1 day accommodation. Kindly give me 1 day accommodation for the day, my lord.
I have already served.
One
Yes,
day
yes, I've been
accommodation.
served.
All right, not today. Next.
ওটা রেখে দেবেন।
You take it back, file it on the
that
next
day, my lord.
Next.
54.
54, I beg to appear on behalf of the petitioners, man. On the last occasion, my lord,
I'm appearing for
there was an
the airports
extension to
authority.
file the opposition on behalf of Union of India. My lord, they have filed.
At last, you
Now-
could. So you have to file your reply.
My lord, right now, notifications has been relied upon.
You
There
don't
is no,
wish to file any reply.
right now, my lord, we have the instruction notes. If required, I will crave that leave if required at all.
Thank you.
May I just indicate the issue in brief? My lord, 1994, two entities One is National Airport Authority, which was a schedule.
But Mr. Chakraborty, you said if required, kindly go through that.
My lord,
You
we
been
have,
served with the copy.
my lord, yes. My lord, factually, there is no differentiation in this.
So I take it that you don't wish to file any reply. Yes.
My lord, let me start. Let me start, my lord.
Yes.
Because I'm led by Mr. Mojumdar, but let me try. Let me try to place the matter. I will
Then I'm
get a
keeping it
scold
on the
from
next
him.
day.
I will get a scold from him if.
Then I'm keeping it on the next
Because
day.
from instruction from the client is that they have nothing to say in this, because it was all admitted documents what has been relied
How
upon.
much time it will take?
It will take some time because we will.
Finish.
3:30.
Taking it up.
My lord, then that will happen again, my lord.
All
I
right.
will miss the bus
All right.
for the time being. I'm just indicating brief, but it will take some time to indicate in brief. My lord, what has happened is that here we have challenged 2 letters issued by the Airport Authority of India, wherein it has been decided that an increment, additional increment granted in the year 1994 will be withdrawn and consequential steps will be taken, including the steps of recovery. But what is the history? The history is that, my lord.
So there are two aspects.
Two aspects.
One is whether they can recover.
Recover.
Even if they can withdraw, whether they can recover.
Absolutely.
That is one part.
One part.
The larger issue would be whether they can withdraw that.
My lord, 1994 Airport Authority of India Act came into force. My lord, 2 organizations. One was a Schedule A organization, that is National Airport Authority. We were employees of National Airport Authority. An International Airport Authority, Schedule B organization.
We were National Airport Authority.
Before 1994. My lord, these 2 organizations merged, Airport Authority of India came into force. Since being a Schedule A organization, we were enjoying better space scale, etc., etc. We were at a, let us see, 1 step higher in every aspect. Now this merger.
1 step higher than the International Airport
International Airports Authority. Well, as a consequence of this merger, we were brought at par.
So you were brought down.
I was brought down. We were brought down. Now, my lord, as a consequence of this, we raised this that all along we were enjoyed higher pay. Everything was greater. We cannot be brought down. So kindly consider this aspect. So what was done? An additional increment was in the nature of personal pay, was sanctioned and granted.
For those who were absorbed in airport authorities after merger.
Yes, ma'am. Every employee of National Airport Authority were granted this benefit.
So this pay will be personal to only those categories of employees, but not to all. After they retired, it will be
retired. That's it. Because to maintain that status of being a Schedule A organization and Schedule B organization. Well, this continued for innumerable point of time for almost 20 years. Now,
20 years.
2015 was the first time when they say no. Since it is not approved by the ministry, we are going to withdraw this and recover, etc., etc. But we say our main point is that you cannot do that. Why you cannot do that?
Mr. Chakraborty, there is no dispute that it was not approved by the ministry.
Yes, my lord. And there is no dispute.
No dispute.
No dispute.
And this pay scale is subject to the approval of the ministry.
No. Here the issue is, my lord, the primary issue is that we will be relying upon a memorandum which Union of India has also stated, wherein the ministry's decision is that CPSE, that organization like Airport Authority, they have to pay it out of own resources, this personal pay or whatever addition. We have no objection to that. If they pay it, the expenses, whatever have to be borne by them. And on the basis of this, my lord, what we have stated.
is a prerequisite, Mr. Chakravarti.
My lord, this
Even then, approval is a prerequisite.
my lord, whether the approval was a necessity in our
So
case.
Majumdar was appearing in one of the matters.
Here, this matter. I am led by
More or less identical issue. I have decided that matter. Mr. Majumdar must be aware of that.
cultivation matter. Cultivation matter. Yes, ma'am. We have seen cultivation. My lord, may
You are led by Mr. Majumdar. He is aware of that.
cultivation matter.
So here, there also these two issues were there.
So it will be more. So it will be more interesting because now the judgment is there, and how we are going to differentiate if it is. I have not seen that judgment. I have been made aware that.
So Majumdar, I do not know whether he has seen that judgment, but
Definitely yes.
he argued on that.
Similar matters are also pending before 25. This means institution, Bose Institute. The institute is only Bose Institute.
Because there also that approval was not there. And all other things were there. There also this, a portion has to be made up by that institute. A portion has to be by the, here also I think a portion of the grant is to be made by the ministry.
Entirety by AL.
Entirety.
Ministry had no role. Ministry had.
So there must be that distinction, because in that matter the maximum allocation was by
Perhaps
the
this
ministry.
this judgment which my lord has delivered in that cultivation matter, Mrs. Alam will be referring before Justice Shamonto. Same. There is a that my lord has said now some portion has to be, some contribution has to be from the ministry also. So there is
that
also
memo is there. That memo is there, for which I have held that the approval of the ministry is a
necessity.
Because the financial liability is upon the.
My lord, here there was no such case. Here, my lord, may I just in the first, very at the instance, indicate what I am challenging, the relevant documents. My lord, kindly first take note of page 133. 133, 133. Here, what my lord will see during the course we are going to show, my lord. Here, ministry is also say ministry. No, sorry, the airport authority. My answering respondent is saying that see, this was granted because it was a necessity, and there was no fault. So kindly approve. This is the stand. This was the stand of airport authority itself. Now they are saying no, we are going to withdraw. Ministry is not saying anything. Practically, airport authority at one instance was saying that no, this was a necessity, for this reason this was granted. This was the very first their stand. After that, this letter has been issued. My lord, may I just indicate the first of the challenge? My lord, may I just read?
Yes.
I am writing to you in respect of this has been addressed by the Ministry of Civil Aviation, my lord. I am writing you. Yes, 4th September 2015. I am writing you in respect of the matter regarding regularization of increment granted to Airports Authority of India employees on unification of pay scales consequent upon merger of International Airports of Airport Authority of India and National Airport Authority in 1995 by an Act of Parliament. The broad issue is related to revision of pay scales of executive with effect from 1/1/2007, taking into account the additional increments granted to the executives of NAA and IAAI as a part of the unification process. The case has been seen by DP earlier and their comments were received by such and such. The salient features of the case are as under. Two different organizations having different schedule of companies, that is IAAI, which was the Schedule B PAC, and NAA, which was Schedule A PAC, were merged. Moreover, NAA being Schedule A PAC were following higher scales of pay as compared to IAAI, which was Schedule B PAC. Accordingly, as per provisions laid down in Section 18 of the Airport Authority India Act 1994, an expert committee was set up to evolve the principle of integration and seniority and other related issues with the merger of erstwhile NAA and IAI into a unified into a unified authority as the Airport Authority of India from 1st April 1995. The broad terms of reference of the committee were to evolve principle of integration of seniority, service conditions of employees of both the division, and to develop unified pay scale, etc. The report of the expert committee was placed before Airport Authority of this has not been Airport Authority India Board in 17th meeting held on 25th March 19.
What happened after this? What is the
My lord,
decision
after
taken
that,
on
I'm
this?
sorry, my lord, I am wrong in some aspect. After that, a further letter has been issued. 2 letters were issued, wherein the orders.
No, show me the decision taken on the
I'm-
basis
I'm-
of this
I'm
recommendation.
sorry.
And this was
My
a
lord.
prayer for reconsideration.
Reconsideration.
So what was the original decision?
My lord, kindly take note of 143.
143.
Yes.
What is 143?
My lord, this is the airport authorities of India's communication address to all the regional executive director of the decision that they have taken regarding this regularization of additional increment that was granted in the year 1994 with effect from 1997.
Yes.
My lord, may I just read? Kindly refer to a CHCO office order dated such and such 15 May 2009 revising the pay scales of the board level and below board level executives of AI with effect from 1/1/2007, wherein it was mentioned that the additional increment granted as an unification package to the executive will be provisionally considered for fixation of pay subject to approval of DP. Accordingly, a proposal was forwarded to Ministry of Civil Aviation and to DP on 16/3/2011 for conveying ex post facto approval for the additional increment granted to the executive at the time of unification. Further, DP has conveyed by letter dated such and such to the Ministry of Civil Aviation that the benefits were granted on account of additional increment extended to the employees of AEI are in contravention of DP guidelines, hence not in order, and further advised to make recovery from the employees. The Ministry of Civil Aviation, by their letter dated such and such, advised the following action. The excess payment made towards additional increment allowed to their employees after fixation of pay in 1997 scale of pay may be recovered. The pay of the executive is required to be refixed after ignoring the benefit of additional increments allowed as personal pay as on 1/1/2007 in view of DPOM dated such and such and April 2, 2019 as indicated in the presidential directive issued by the Ministry of Civil Aviation. The approval of Board of Airport Authority of India was communicated to the Ministry of Civil Aviation. Accordingly, the Ministry of Civil Aviation requested Department of Public Enterprise to reconsider the case and agree to the regularization of the additional increment being an extraordinary situation of merger of two different schedules of organization. The Ministry of Civil Aviation has further advised AI to prepare a draft cabinet.
This is the impugned order which you are challenging.
This is the first, and there is another impugned order which my lord will find at page 145. The very next page. In pursuant to that first order, which I showed to my lord at page 143, there is the second part. In accordance with para 9 of CHQ, letter of event number dated 12 July 2016, all REDs, APDs, Kolkata and Chennai should ensure the course of action taken in respect of the following. Formulation of a committee of involving HR and finance officer headed by GM such and such, recalculate the pay fixation of all executive who got benefit by way of additional increment, also who were drawing AM scale such and such. Considering, therefore, my lord, these are the two. My lord, kindly take note of page 146 once. As per instruction content, I'm reading the very first paragraph. What will be the effect if it is recalculated and that additional increment is taken away?
There are two aspects. One is recovery. Recovery, whether they are entitled to.
My lord, that we will
have a.
That we will rely upon only one judgment, my lord, that Thomas Daniel judgment, because it covers everything. Massey has
also followed that. In that cultivation matter, I have said no recovery.
So that the main issue
part is one thing, but
main issue is whether this, as has fallen from my lord, correct, absolutely, that whether this increment which was granted to us was proper or not. We have to show yes, they have to show no. After we have to make another extra mile endeavor to deal with it, keeping in mind the judgment of the cultivation judgment.
Almost identical. Minor
So what will be, yesterday I
differences.
came across a term, I was not aware of this, intelligible differentia, intangible differentia. When I am reading that term, means unequal should not be treated as equal, and equal has to be treated equally. I came across this term, my lord. Here, we will be relying upon for the fact that at the time when this was granted, or when this additional increment was given, this was between two unequals.
No, what is the DP guidelines?
My lord, DP guideline
Because
of
it
2008.
says this is in contravention of DP guidelines.
My lord, DP guideline, first kindly, my lord has seen that they have referred to one guideline dated in they have referred, my lord. First, my lord.
As a result of this merger, Mr. Chakraborty, was any option given to you to leave those service?
No.
Has to be.
No.
Option has to be.
Because that occasion to give that option never arose. Why we say, my lord? Because when this situation happened, immediately dispute was raised. That see, this is we have brought at par an unequal to us. So kindly consider whether anything can be done in our favor or not. Simple this representation. On the basis of it, what was done?
This decision of merger was taken at the highest level of the ministry.
Absolutely at the highest level.
So if that was taken.
Yes, I can follow that there must be something of the government of India.
Now Mr. Majumdar has come.
My lord, I am led by Mr.
To some regard, Mr. Majumdar, have you seen the cultivation judgment?
Yes, yes.
Issues are somewhat identical. May not be same.
I'll be supported by that judgment.
Will be supported by that judgment.
Because not in that case, your lordship held that this was not approved by the government.
Here also it has, as Mr. Chakraborty said, not approved. But
Factually,
according to you, it will be the merger while
Factually,
approving the merger, it has been accepted.
I just read not 2 pages from the opposition of the employer. The employer for the now this is with reference to 1995 situation. In 1997, there was a pay revision. No dispute with that. 2000.
When the merger took place.
1995, with effect from 1/4/1995. That's the statutory document. Now, when in 1/4/1995 the merger took place with grant of 5 additional increments to a class of employees, and then the pay was fixed with effect from 1/1/1996 in the 5th pay revision. The 6th pay revision took place in 2006. The first objection was raised with regard to the 6th pay commission in 2009, not with regard to the 5th pay commission. So, the action of granting additional increments and approval of pay scale with effect from 1/1/1996 after 1/4/95 merger got concluded.
No, when this decision was taken to allow this personal pay.
94/95.
Now they are trying to withdraw that. So that basis is they are trying to now withdraw.
Right. So 1/4/1995 there was grant. 1/1/1996 there was pay revision with this grant.
According to you, that was approved. Additional increment or personal pay or additional pay in whatever term you may call. So that was approved by the government when the merger was approved.
Merger was approved, number 1. Number 2, when the 1/1/1996 pay scale was also approved. Not they don't question the approval of pay revision. Not there are 2 things. One is pay fixation, the other is pay revision. pay fixation with additional increments is fixation for this particular class of employees. Revision is in the scale of pay. Revision of pay fixation is something foreign to service jurisprudence. So the revision of scale took place on 1/1/1996 with these fitment benefits or additional benefits, not objected to even today.
So you are fixed in that revised pay scale
with the additional
by
increments.
taking into consideration these personal
5
pay.
additional increments. So that 1/1/1996 pay revision with the additional grant is not questioned even today in 2025. What is questioned is in 2009 with effect from 1/1/2006.
1/1/2006.
Yes, please come to note the opposition of the employer.
Which Ms. Alam filed today.
No, Miss Alam's affidavit is only not disclosure of certain documents, not which does not alter my case. Please come to note the affidavit in opposition in the back sheet of respondent number 4.
Who is representing the
I'm appearing for respondent number 4.
Na bhai, no. Please come to page 9.
Let me find out that opposition.
It's a longish one, should be in white paper, in legal size.
I found the affidavit in reply. এই এফিডেভিটের অপোজিশনটা কোথায় দেখুন? রেসপন্ডেন্ট নাম্বার 2, রেসপন্ডেন্ট নাম্বার 4 একটা দেখুন তো কোথায় আছে?
It's the back sheet of Mr. Vivek Jhunjhunwala.
এটা রেকর্ড করুন তো।
হ্যাঁ, ওইটা
Affidavit in opposition filed by the This Alam, this is only by the respondent number 2.
A4
The back sheet you have said 1 to 4.
Cut, copy, paste, lordship.
Kindly correct this, otherwise it had to din. Affidavit in opposition filed by the second respondent is taken on record. পাওয়া গেছে? পাওয়া যাচ্ছে না? হ্যাঁ, কেন তো অর্ডারে আছে, ফাইল করেছি।
Can ওটা?
What a can. There are a lot of cans.
ওটা can. I just read not till such time not the document is searched out.
Yes.
In the 25th board meeting of Airports Authority of India, held on 23rd January 1998, it was decided that the
Yes. Page?
Not page 8.
Yes.
Not paragraph 4.
Paragraph 4, yes.
An expert committee was constituted in respect of Airports Authority of India in order to give effect to the merger, common service conditions and other related issues. The expert committee in its report had proposed that the pay scales of National Airports Authority may be made applicable to International Airports Authority of India executives, in the unified authority being the Airports Authority of India. The expert committee submitted its report on 31st March 1997 and suggested unification of pay scales and designation in the unified authority with effect from 1st April 1995. In the 25th board meeting of AII, held on 23rd January 1998, it was decided that the executives of erstwhile NAA up to the level of manager would be entitled to 1 increment, and from the level of senior manager and above would be entitled to 2 increments with effect from 1st April 1996. Now, that's the basic factual scenario. Now, please come to the next page. Not first, 4th, 5th, 6th, 8th line from the top of that page. Not the sentence beginning from the extreme right hand side of the line with the word while. while issuing the order for revision of scales for board level and below board level, so this was pay revision for all employees, that was pay revision of AI with effect from 1/1/2007, that's after 10 years, that's the sixth pay commission. As per office order dated 15/5/2009, wherein at para 2.3.9, wherein it was clearly mentioned that the additional increment granted as a unification package to the executives of Airports Authority of India of office order dated 26 February 2002 will be provisionally considered for fixation of pay. So what happens between 96 to?
Next sentence is
Yes, please see.
important.
This is, however, subject to approval of DPP as mentioned in the above referred. So what was
That is subject to
from 1/1/2006? At the most from 1/1/2006? So this is at the most with effect from 1/1/2006 pay revision. And it is not relating back to 1996 pay revision.
So according to you, prior to 2006, it cannot be altered.
So if 1/1/1996 pay commission's recommendation has been approved with this additional grant for these classes of employees, 2006,
Whether in the subsequent it can be.
it's a fait accompli. It's a fait accompli. But there cannot be two different standards, not or two different phases with different standards.
Yes, because it happened prior to 2006.
And from 1996 to 2000,
at one stage you have accepted this, whether at a subsequent stage you can take back that.
Consequential only.
And they are not disturbing the earlier one.
So that I stand supported by the.
So when Mr. Chakraborty was starting, it went in my mind that similar issues or more or less identical issues were considered. Then I asked Mr. Chakraborty whether he has considered when he took your name. I told him that you must be aware. I do not know whether we have gone through that judgment.
No, I have gone through that. I read this affidavit yesterday night, not in a different perspective, keeping in mind that judgment.
Yes, how much time you will take?
Not I need to place Miss Alam's affidavit. Not that also supports my case.
How much time you will?
Not another 20 minutes or 25 minutes.
Do you wish to continue today?
But I can.
I am in
You can.
I'm in difficulty now. Actually, I have a meeting from 3 at a virtual meeting. That is why I couldn't.
Then Mr. Mujumdar, she is.
No, I don't.
All right. ওই উপর একটা থাকবে কিন্তু এফিডেভিট যেটা Mr. Mujumdar, learned senior advocate, assisted by Mr. Chakraborty, commences his argument but could not conclude due to paucity of time. The respondents are represented. All the respondents are represented.
My lord. My lord,
All the
we are
respondents.
appearing for all the 4 to 7.
Representing Union of India. Both the
We are appearing for
delegation and
4
The respondents are represented by their learned advocates. List this matter under the heading continuing matters in the next week. Huh? Next week মানে Monday থেকেই করে দিই যেদিন হবে। Yes, Mr. Dev Burman, which matter?
I think for item number 61, it may be
61.
It may be taken up for next week. By original was Thursday. I will not be here. That's my problem. That's why I was waiting.
Or you don't want in the next week? 61. You are for the petitioner. Who is for the respondent?
I am for the main answering respondent bank. My lord, 61 and 62 are similar matters.
So, in the week starting from 20th, you want?
Plus.
Ashun. 61 or 62 te at order record করে দিন. As paid for by Mr. Dev Burman, learned advocate for the petitioner. List this matter in the week starting from January 20, 2025. The learned advocate for the respondent is present.
আমি জানি না